So as in our previous lecture, we had seen intellectual property. What is intellectual property? What are the things that we can consider that can be protected under the intellectual property, right? We have seen that intellectual property is nothing but a creation of mind where we can protect any invention under the IP framework of patent, then the copyright, where the literary work or cinematographic work we can protect under the copyright law. Then any type of logo or any type of tagline that we can protect under trademark, right? Then the industrial design is there, or the design patent is there, where any type of design that if we feel that it is a unique and we want to keep that design for our further industrial benefit and all, so that thing we can protect it under the heading of design patent. Then industrial design is the one thing where the infrastructure, or if anything specific we can say the design or the infrastructure is there. Industrial design is that we can protect under the industrial design. And the most important, that the one that relates with the geographical things, like that the orange from the Nagpur or Banarasi silk sari, or the different things are there. Specifically in India, we have that different traditional things, and that geographical indication we can take for protection of this particular geographical, like Hapus from Ratnagiri. So that for that particular things we get that geographical indication. So this is what the intellectual property. So moving to the first one, patent. That patents, or we can say this is a simple document. That document is generated, or we can say that is issued on application by a government office or a regional office acting for several countries. So this is actually a document we get upon application from the government for any type of invention, right? Then the document, what it mentions, like as we generally have for pharmacy, we have the particular certificate or MH, that Maharashtra Pharmacy Council certificate we get after completion of our bachelor's or diploma, right? So likewise here, this patent is the one document that describes an invention and creates a legal right under which the patent and invention can normally only be exploited, manufactured, used, sold, imported with the authorization of owner of the patent. So this is the one that documents gives us a right that to manufacture or to use or sold the imported or import anything, and it should be under the authorization of owner of the patent. So you're not allowed to share anybody's invention directly. You need to take permission, and definitely under this patent document will get protection. And this is the single right, that monopoly right. So if the owner of the patent is there, so he or she may have the monopoly right for the patent. Nobody else can directly use that invention or sell that invention in the market, right? He or she or any other person who is not a part of the patent document need to take permission from the owner of the patent, and definitely in between the 20 years of time period which is provided by the government to the patentee. The significance of right is statutory right. It is a legal right to prevent others from exploiting his invention. So generally the patentee get the right to protect other, or to prevent others from exploiting their invention, exclude others from making, using, or selling his invention during the protection time period. Then the right to take action against any person exploiting the patented invention in the country without the permission of patent owner constitutes the patent owner's most important right. So this is the most important one. If you have invented something and you have a patent for the same, you have rights for the same, and if anybody else is selling or manufacturing the same invention or selling it into the market without any authorization of the patentee, so that time the patent owner can take any action against the other person. Now, this permit him to derive the material benefit to which it is entitled as a reward for his intellectual effort and work, and compensate for the expenses which her research and experimentation leading to the invention have entailed. Generally, any invention, for even in your masters, you generally go for the research work, and if you have invested your time, your money for the invention, and somebody is using that invention without your permission, so that time you may ask if somebody is using your experimental conditions, your research protocol. So, and if you have registered it under the law, then definitely the other person need to compensate it by any sort of expenses or anything which is mentioned as per the Patent Act 1970. Interestingly, the state grants the patent right. So generally for India, if I say the state grants the patent right to the patentee, then the state, however, cannot or will not force the patents by using, but by suing on behalf of owner. So generally, yeah, on behalf of owner, the state cannot enforce the patent. Like definitely, they need the permission from the owner of the patent. It is up to the owner of to enforce his right by suing for what is called an infringement of her rights. So if anybody is using invention without owner's permission or by exploiting the owner's right, then definitely it comes to the infringement, right? And thus the right is vested on owners, unlike criminal law where the state enforces the right on behalf of victim. So here generally state is not allowed or not take any of the action. The whole thing is associated with the patentee. Although in case of criminal law, if anything is going wrong, so that time state is also take a right or enforce the right on behalf of the victim. But in this case, generally the rights are associated to the patentee or the patent owner. This right is vested by the state, provided by the states on the owner in return for the disclosure of invention. Okay, so this is the patent. So most of the time in pharmaceutical industries, that most of our pharmaceutical products are protected under the Patent Act 1970. Understood? So most of our formulations generally protected under the patent. Fine, because most of them are invention, that most of the experimental designs are invention, or most of the products are invention. So you need to mention the one thing, that it is showing more efficacy, or if you're claiming any process, that process should be of the acceptable mode, or it should be advanced, it should have a technical advancement in comparison with the existing process, right? Understood everybody what is patent?
Yes, ma'am.
Yes, ma'am.
Okay. Now the next important thing in a patent act, they have not mentioned what is a patent, right? What is patentable invention? Although in the Patent Act 1970, the subsequent amendment 2005 do not answer the question what is patentable. Instead, it contains provisions of what does not constitute an invention. So instead of mentioning what is patentable, they have mentioned what is not an invention. So section 3 of the Patent Act 1970 lists the inventions which are not patentable and which are not covered under the heads of invention in Indian patent law. So instead of mentioning the invention, what they have mentioned what is not an invention. So definitely if anything is not coming into the criteria of not an invention, then definitely it goes to the invention one. So again, these 3 things or 4 things which are necessary that make your work or research work or experimental work eligible for patent. So here this NUNS test, that novelty, N stands for novelty, that is new requirement, utility, that is industrial applicability, non-obviousness, that is inventive step, and statutory subject matter, it means that which not falls under the section 3 of the Patent Act 1970, because as I mentioned, section 3 is specifically associated with what is not an invention. So anything which is not falling under this section 3, that comes to the statutory subject matter. So here the first 3 things are very important for patentability criteria, that is novelty requirement, that is new. Second is utility, that is industrial applicability. And the third one is non-obviousness, that is inventive step, right? So these 3 things are required for patentability criteria. Now the first one, that is novelty, right? So that novelty forms the primary reason that makes the invention patentable. This is the primary reason that make the invention patentable, that what is the novel, right? That subject matter should be like, when you're thinking for the patentability, so you need to check that whatever you are claiming, it is not published before, not claimed before, or not publicly used before the application. So when you are going for the application for your work or research work or whatever the idea you have, which may have the industrial applicability and utility, so that time you need to check, is it published earlier or not. So this is the subject matter for novelty, that stands under novelty. Then determine through that, how we will check, we will determine through extensive literary or patent search that is it novel or not. So if it is available in the literature, if it is available in the publication, so definitely we cannot claim it as an invention or novel, right? So for that we need to go for the extensive literary and patent searches. Then once an invention is made public through publications anywhere in the world, it ceases to be novel. So if anybody published it earlier, then definitely it sees the novelty of the patent, right? So these are the things that need to be known or need to be assured when you are planning even for your work. So you need to check, is it novel or not? Is it published before or not? Is it claimed before or not? Or is it in a use? Okay. So definitely it helps in your planning. Now, what exactly the definition of invention as per the Indian Patent Act 1970? So invention means a new product or a process involving an inventive step and capable of industrial application. So invention means what? It means a new product or process involving an inventive step and capable of industrial application. So these three things are required as per the definition section 2(1)(j). And what section 2(l) stands for? New invention. You can see here the difference, invention and new invention. So again, what new invention means? Any invention or technology which has not been anticipated by publication. Anticipated means not discussed earlier by publication in any document or use in the country or elsewhere in the world before the date of filing of patent application with complete specification, that is the subject matter has not fallen in a public domain and that it does not form part of the state of art. In simple word, if we are claiming it a new invention, so it should not be anticipated by any publication in any document, as should not be used in a country. Even while submitting your application, it should be a complete specification. So generally, when we submit the patent document or patent application, generally it is in a two format: the provisional specification and complete specification. Provisional specification means as you have done an initial work of your work, and definitely any research work is will take generally 2 to 3 years for completion, right? So in the beginning, if you have done just a pilot work and you would like to submit it, as because if in coming 1 to 2 years, if somebody submit the application for the same, right? So definitely the novelty get hampered. And that's why if you would like to give the initial application, so you can give the pilot work, right? So that comes to the provisional application. So here you can submit simple abstract of your work and the methodology. And later on, in 1 year, you can submit the complete work. And if I talk about the complete specification, so here you have to submit everything of your product, of your work, that the abstract, introduction, background work, claims, then the diagrammatic presentation, everything. So you need to submit the complete application at the stretch. Okay, so this is what actually required to claim the novelty. Three things: new product, process, then second inventive step, and third capable of industrial application. So that if these three things are there, then definitely it will be called as a novel or new requirement. Now the important thing is non-obviousness. So in this is known as inventive step. Non-obvious. Obvious means what? If something you are thinking and it is obvious, okay, fine, this type of reaction will happen definitely. So that is obvious. Non-obvious means what? Which was not initially obvious, but you have developed something new, you have invented this, that the inventive step is called as non-obviousness. So it refers to as substantial technical advancement. So that comes to the non-obviousness. So in any process, in any research work, if you have done something technical advancement, right, as compared to the existing knowledge. So initially, we say generally initially the conventional tablets comes, then after the gastrointestinal tablets were there, then after double layer tablet were there. Nowadays that we are majorly working on nano formulations. We are entrapping that nano formulations to the transdermal drug delivery system, even the dispersible tablets and so on. So this is what the substantial technical advancement. Okay, so that substantial technical advancement means that inventive step is required. Okay, then comes to the invention should hold some economic significance. Economic significance to qualify the as an inventive step. So definitely you are claiming that something should be economically significant, like it should increase the value of that product, right? It should have an economic significance. Then a patent application involves inventive step if the proposed invention is not obvious to any person skilled in the subject matter of the patent application. So as per the Indian Patent Act 1970, the definition is here, section 21JA. It means a feature of invention that involves technical advance as compared to the existing knowledge or having economic significance or both. What? It is having a technical advance than that of the existing one, or second, economic significance, or both, right? So that makes the invention non-obvious to a person skilled in the art. So this is non-obviousness. So this is the second patentability criteria your research or your experimental work should have to make it patentable. Then this is one of the example. It should not be a very complex, like if you're saying if I want to patent something, so that time I need to do something complex or difficult type of research work. So it's not required. Even a simple workbook, but if it is satisfying three criteria, that is novelty, inventive step, and industrial application, definitely, so that is acceptable. So you can see the complexity or simplicity of inventive step does not have any bearing on a grant of patent. So here you can see the example that invention of coffee collar. So this is the coffee collar or coffee sleeves can be classified as a simple inventive step. This is a simple inventive step, but should not again confused with a frivolous. This is what just for holding purpose, like to protect your hand from getting warm, right? So this is a non-obvious thing, although it is a simple and definitely it is useful as well. So this is non-obvious, right? Frivolous invention means which is making which is sort of frivolous means that is not against the natural thing, that is not expected, that is frivolous. Now, the third important thing is the utility, that is industrial applications. So that invention is useful when it is capable of industrial application. Capability of this industrial application refers to the invention being made or used in an industry. So here the requirement is what? It should be made and used in industry. Okay, it is not like that it should be used in industry only. Okay, so if I'm claiming utility, so if I have registered something, or I have I am preparing something in India, so it should be used, made and used in same industry, or it can be made and used by other industry with the permission of the patent holder, right? So it's not like that it is to the particular device only. This is the single machine will going to produce the same. No, if it is an invention, it should be made and used in an industry anywhere, right? Because you are using the same specifications. And definitely it is up to you. When I'm saying I'm working on something, so I know the procedure, and if I'm going for the patentable things, so definitely the patent document will be reserved at my end only. Use here means a repeated use which yields the same result every time. So that is nothing but the, if I'm claiming use here means a repeated use which yield the same results every time, means what it means?
Repeatability.
Repeatability will give the same result, means what is what is the name of our subject? Validation, right? So this is what we are claiming, whatever the things or repeated use which yield the same result every time. So this is what we expect from the work, that it should give the same result every time. And this is the definition as per the Indian Patent Act 1920. So section 21 AC, it's capable of industrial application in relation to an invention, means that the invention is capable of being made or used in the industry. Fine. So this is the utility. And the last one is the statutory subject matter. This invention falls within the statutory subject matter if it is not covered by Section 3, the Patent Act 1970, and Section 3 lists the inventions which are not an invention within the meaning of Act. So they have mentioned, or they have given specifically what is not an invention, right? So, okay, and this is the Section 3A, where some inventions are frivolous. I'm not taking in depth because you do not have this language or this legal things, but definitely for your understanding, you must have to know what 3D stands for or what inventions are not an invention, okay, but that we cannot patent. So frivolous means if anything is contrary to well-established natural law. So on the right-hand side, you can see the dimple drill. This dimple drill is prepared with the stainless steel or some iron material, and the purpose was to keep it into the mouth, and that will give the artificial dimple, right? But it is difficult to carry this iron or dimple drill inside the mouth, and again, it's natural law, right? So it's contrary to the well-established natural law. That's why it is not an invention, okay? It's not having any type of utility. Then any invention that is contrary to the public order. So if you would like to register a patent for apply for the patent of currency copier, okay, so it's not possible because it's government right. Government is doing the currency copier, is having the currency copier. You or me cannot do this, right? So that contrary to the public order. Preparation of poison, is it having any type of utility? No, right? If you are creating any type of poison, this is a unique poison. By taking a one drop within a second, human can die, right? It's easy for dying, or if somebody is frustrated with the life, can die in a second. So we cannot say this is an invention, right? It's against the public order. Fine. So it is a serious prejudice to the human and animal or plant life or health. So that is not an invention, although it is dying the people in second. Then mere discovery of a scientific principle or formulation of abstract theory or discovery of any living thing or non-living substance occurring in the nature is not an invention. So there's the one simple case is mentioned here. So in this, what actually they did, the initial inventors did, they just mixed this different strains, right? And they claim that the mixture of the strain is having some different activities. But the Supreme Court denied it as an invention because it is already existing in the nature, and simple discovery of scientific principle or mixing of the same is not an invention. Or if you are claiming this is the abstract theory, you're not able to relate it with the inventive step and utility, so that do not comes to the invention, right? So the mixture of natural things or 6 strains of bacteria packaged in the one thing, and that you cannot claim it as an invention, okay? The 3D is the most important, where we generally work in pharmaceuticals, that a mere discovery of new form of known substance. So it means the substance is known to everybody, and you are just claiming a new form of known substance which does not result in the enhancement of known efficacy of the substance. If you are saying that you have prepared the substance, that substance is new, but if it is not increasing any sort of efficacy, so that we cannot claim it as an invention, okay? If I say a paracetamol is having the analgesic or antipyretic activity, and if you come with some new activity even, so that is not an invention. If you come with a new form of the same known substance, but if it is not increasing the efficacy, then again it is not an invention. Similarly, a mere discovery of any new property, as I told you, that analgesic, antipyretic, and you have invented something different, that anti-inflammatory, so that new property is not considered as an invention. New use of known substance is not an invention. Mere use of known process, machine, or apparatus, unless such a known process results in a new product or implies at least one new reactant, is not an invention, okay? So here generally we work on the salts, ester, we prepare drug salts or esters or ethers or polymorphs or metabolites, right? From a pure form, particle size, decrease the particle size, or isomers, mixture of isomers, complexes, combinations, and other derivatives, known substance shall be considered to be the same substance, fine? unless they differ significantly in properties with regard to efficacy, right? So if they are not different in the efficacy, they will be called as a same substance. Understood? So while designing any experiment, while designing your research work, you need to check that whatever you are preparing, is it increasing the efficacy or not? So if it is increasing the efficacy, then that time you can claim it as a new product or that patentable one. Otherwise, it do not stand any novelty or industrial utility or utility, right? So this is the one example that a case from Novartis. They have initially filed an application for imatinib drug, and they got patent also grant for that particular application, imatinib. And later, what they just filed application for imatinib mesylate, which is simply a salt form of imatinib, and they asked for the patent. And what the assistant controller replied, they were not convinced, and they replied that it is only a new form of known substance. It is found that this patent application claims only a new form of known substance without having any significant improvement in efficacy, right? So that's why they have not accepted that application and denied from giving the grant to the same application. Understood? So if you're claiming that new form of substance is having more efficacy, then only it is patentable. Otherwise, it is not patentable, right? Then this is one more case, as I hope you understood from the previous case. Have you understood?
Yes, ma'am.
Yes, ma'am.
Okay, okay. One more thing, in this case, actually, this case is between the Roche and the Cipla. This is for Tarceva drug. Initially, the Cipla, the Roche launched that drug in India for marketing Tarceva, okay, and the patent granted in 2007. Further, the Cipla raised the opposition against the filed or grant patent that Cipla also launched the drug named Ilosep, which was the same as a drug by the generic name of erlotinib marketed by Roche under the patent Tarceva. Okay, and the Cipla cost was about 1600, whereas the Roche version cost is 3 times than that of the cost of Cipla. So the matter was brought before the Delhi High Court, and interim order was passed in favor of Cipla as the drug, as we can say, the rights of as per the rights for the human health is concerned. It is of lower cost, right, and it is more easily or affordable to the Indian patient. And as per the patient right of patient, it is passed in order or in favor of Cipla. So this is one more case relates to the section 3D. Now section 3E, stands for mere admixture. So if you have just mixed the things, so definitely if it is not increasing efficacy, so that is not stands under the invention. So if I say the ORS having the mixture of glucose, sodium chloride, sodium bicarbonate, potassium chloride, and we have already learned these things that all these ions have different applications, right? So a simple mixture of it is not an invention, although it is sold by a particular company, that ORS, but it is not having any type of efficacy. Then the mere arrangement or rearrangement of duplication of known devices functioning independently one another in known way is not an invention. You can see umbrella here, and here umbrella with fan. Fan is having a different function, umbrella is having a different function, and they have patented earlier with their individual function. So combination of these two is not an invention. Understood? Yes? Are you getting me?
Yes, ma'am.
Yes, ma'am.
Now in India, we generally do a different type of agricultural, horticultural methods are there, but that is again, we cannot claim it as an invention. Okay, so that agricultural, horticultural methods are not an invention. Now the I, that any process, medicinal or surgical, curative, prophylactic, diagnostic, therapeutic, or treatment of human beings, or any process similar treatment of animals to render them free of disease or to increase the economic values of that their product is not an invention. So whatever process we are claiming, that medical or surgical things, that is not an invention. Otherwise, what will happen if a particular doctor is there and if we say this is my different surgical method, so he will going to get protection for the same, so it will not easily available for the other people. And that's why any process related with the medical, surgical, curative, prophylactic or therapeutic is not an invention and not patentable. Then the plant, animal, whole or any part of plant is not an invention or not patentable. Although some microorganisms are patentable if we have developed it by using a biotechnology or some genetic engineering methods, right? So any biological method or any biological species, plant, animals is not an invention, or we cannot protect it under the patent. Now, this is one more case actually. Here simply would like to quote that that they initially that somebody would like to mention that this is the flower image. You can see this is the natural one, and they have posted their photo on it, and they would like to publish it. But yes, government denied it as this is the photo of natural flowers. So you are not allowed to post your photo, and you cannot ask for the protection that it is for you only, right? So in that case, it's not acceptable by the office. Then any mathematical or business method or computer program is not an invention. It's not patentable. But if the computer, like hardware, is assisted with the software, generally in your HPLC you have a different softwares. So if the software is associated with the hardware, so that time it is patentable one. Okay. Then L stands for literary, dramatic, musical, artistic work. It is not under patent, right? We can get a protection it under copyright. Then M, it's any scheme or rule or performing mental act or playing game. These are not an invention. It's not a patentable. A presentation of information that somebody said, I have my presentation is great. I have presented very well, but still it is not protected under the Patent Act. Topography of integrated circuit. So if anything is topography of the circuit is not under the patented. Yes, it get protection under the Semiconductor Act or Semiconductor Law. Now the invention, which is effect, is a traditional knowledge. Like in India, we have a different locations, we have a different type of people, we have a different cultures, but definitely we cannot get protection for that culture or traditional knowledge. It's not under the patentable, right? So these are all the things that we can say these are not an invention. So you need to like definitely go through the 3D section 3D of the Patent Act 1970, and you have to follow the same. So if your product or your process is novel, if your product is having more efficacy, then only you can claim. Or if you're having a completely new product, then only you can ask for the patent, or you can get the patent for the same. Now the question would be like, ma'am, is it required something hard or something difficult only? So no. So there are so many things, like even a simple chair you are sitting on it, right? Initially, the first one who have invented it, he got patent for the same. So there are different type of very small patents are available for that they got the protection. Okay. So patent is, if I say word wise, it's a document that you are getting for your product. Okay. For your product or for your process. Fine. It should have a patentability criteria. It should satisfy the patentability criteria, novelty, inventive step, non-obviousness. Okay, non-obviousness and utility, that is industrial applicability. Third, it should not stand in the section 3 of 1970, right? It should not stand under section 3 of 1970, Patent Act 1970 to 9, then definitely it may pass to the patentability criteria. Fine. Then moving for the this, I think this, you are clear with this?
Yes, ma'am.
Okay. So moving to the next, that patent prosecution steps. Patent prosecution means patent filing procedure. Okay. So patent filing procedure. So if you have invented something new, right, you need to do the market analysis first, right? And definitely in our pharmacy, we generally go for literature survey, right? To check is it available or not, and then we go for the exclusive strategy, that how we will prepare the same, and then the markets, and then we have to write it in a proper way. The claim is important, that how we are writing the claims, right? Then creating your drawings if you have invented or something that the design of any instrument you would like to protect under the patent, so you have to create the drawings. Then IP application preparation, then you have to prepare the application and then the filing. Okay, so initially you have to do the market analysis. Like if you are thinking for the same key, I'll going to generate some or design some device, that device will help for something new cause, or it will solve some new cause or some other causes, right? So you have to do the market search. Is it available in the market? Is it published somewhere else? Is it claimed earlier? Is it used earlier? If it is there, so definitely you are like, there's waste of time while working for the same. Then once if you found it, no, it's not published earlier, not claimed earlier, then you can make an exclusive strategy for designing for the IP protection. Under which IP we can protect it? Is it under design patent or under the normal patent or copyright or any on it? If specifically we are talking about the invention, definitely it comes to the patent or invention, right? So then the market centered claims means you have to claim that device is used for this. If I am saying like when the stethoscope registered initially, so though they were mentioned that they claim that this is used for measuring the heartbeat, or they have the medical applications. Then creating drawing, that what is the structure of the stethoscope, that they want two connectors for the ear. One is there like the stethoscope, their disc or the circle one with input recognizable, or like audio recognizable recognition is required. And drawing you need to create. Then IP application, preparing the IP application, other documents, and submit to the patent office. So definitely associated documents you have to submit. And filing in application in the office. So nowadays e-application is also possible, through which you can file your application to the patent office. So generally the Director General, I have already showed you that the controller of patent, right, generally responsible for the same. For Maharashtra, we have to file the things in Mumbai office, and in our Nagpur, we have a patent information system. So here the patent prosecution steps or patent filing steps. The first step is filing of application. So there are 5 applications, but if I say major ordinary application, complete specification application is there. So the first step is filing of application. In 18 months, once you file the application with complete specifications, जहाँ पे पूरे specifications दे दिए, if you're not filing the application with complete specification, तो पहले first you have to give the provisional application where you have to submit abstract, and within 1 year of span you have to give all the details, right? So this is this provisional application or complete specification application. Once you submit the complete application, after 18 months the publication would be there from the IP office. Okay, and if any opposition is there, so definitely that would be received pre-grant opposition for the same. Then if you received any opposition, you have to answer the opposition being applicant, right? If no opposition is there, then you can request for examination after 48 months from the filing date. You have to ask for the examination. Okay, once examination done after 48 months from the filing, either they will grant the application or reject the application. What they will going to check? They will going to check that patentability criteria, novelty, of non-obviousness, right? That is inventive step, and industrial utility. If all the criteria are satisfied without opposition, definitely they will grant the patent, and that from that time the patentee will get 20 years of monopoly right or the exclusive right for using that patent document. Okay, then if any opposition is there after granted, after publication of the patent, if any opposition is there from any industry, so that is called as post-grant opposition. That again goes to the IP office. IPT office is there, actually appellate board is there for IP. And if no opposition is there, then again the maintenance is for 20 years. So this is the patent prosecution step. So for 20 years you will get the maintenance for the patent. Okay, so this is the procedure that how you can file the patent application. Understood? Filing the application, after 18 months publication would be there. Pre-grant opposition, if any, then you have to answer the same. Then you can request for examination after 48 months from the filing. Once examination done, either you will get a grant or rejection. Once you get a grant, the maintenance would be for 20 years. If any post-grant opposition occurs, then you have to answer it within the 1 year. Fine. So this is the patent prosecution step, right? Now who can apply? So anybody. true and first inventor. If I said you have invented something, so you are the true and first inventor. Any that true and first inventor can apply for the same. Through institution you can apply. Assignee is what assignee for the same. So if I say college, where you are working, that college will be act as a assignee and you will be the true and first inventor. So in case of patent, generally all the authors are having the equal right. Even in case of publication, the first author or the corresponding author have a more right than that of the middle one, right? But in case of patent, all the authors have an equal right. And the third is the legal representative of any deceased person. So if any person, deceased person is there, so that time any legal representative, any patent agent or patent attorney might be act as an applicant. Okay, so who can apply? Who and first inventor, any assignee, and legal representative. Are you getting me?
Yes, ma'am.
Right? So this is that who can apply. Now the second is obtaining patent. Like I have told you, there are 4 branches, 4 offices are there, patent office branches are there: Mumbai, Chennai, New Delhi, and Kolkata, where you have to file your application. And in its e-filing, it's really easy. You can go to the ipindia.nic.in and you can go for the e-file. So they have a different fee structure for e-filing and for the manual filing. And again, if a signee is there, definitely it's different. If a single inventor is there, then the fees is different. Now, patent filing, that as I have told you, that who can file: inventors, the true inventors, assignee, legal representative. Where to file: jurisdiction, offices, Chennai, Kolkata, Delhi, Mumbai. How to file: you have to fill the required forms and you have to submit the fees. Then type of patent: application, ordinary application and extension application. Ordinary application may have a foreign applications. You can file it for a foreign application, means your invention, if you would like to launch outside the India, like in abroad. So that time you can go for the foreign application. Convention application means you can go to the individual country and file the application. PCT is Patent Cooperation Treaty. So under around PCT, there are 153 countries. So if you file PCT, so it will get filed under 153, or if you mark at 10 countries at a time, so you can protect it under 10 countries, right? So you can apply, submit application for 10 countries under PCT and for a single conventional application. Then complete and provisional. I have already mentioned you that complete and provisional. Extension application means like if you have already submitted your patent application and you have some addition or data over there, so that time patent of addition you can submit for the already existing application. And the second one is the divisional application. So these are the type of application, how to file, who can file, and where to file, right? Provisional specification: after 12 months you have to submit the complete specification, and it should include title, field of invention, background, summary, list of drawings, description, claims, and abstract. Fine. So this is the filing strategy actually. And if you file provisional specification first, so it will give you a priority date. Okay, as I have told you, I know very well 2 years mein isme study aane wala hai, but this is my invention. I thought it first, or I have designed it first. So I'll go for the provisional application. I'll get a priority date. Within 12 months, I'll submit the complete specification, and definitely I'll get the grant on the basis of the priority date. So if I get it on a priority date, so the rights would be mine. Fine, initially. Then these are the some important forms for provisional specification: Form 1, Form 2. Form 2 is specifically where we submit the provisional specification and complete specification. Form 3 and Form 26. Here, Form 1, Form 2. Again, complete specification in the Form 2, Form 3, Form 26, and inventorship declaration jo hai, that we have to give in Form 5. So these are the mandatory forms we have to submit when we are filing a patent. Okay. Then as I have told you, after 18 months, publication would be there. For examination, you have to request after 48 months. They generally ascertain the novelty, utility, inventive steps, statutory subject matter, and application formalities, and then issue the first examination report. And once they issue the first examination report, within 1 month, you have to give the answer for that first examination report. And then after, they will proceed for the grant. And then issue offer, that how much time that we have to submit the things. This is again in more detail we can say. For your understanding, we have to know the filing procedures and how many months that publication will be there, and how many months the examination is there. So this is for what about the prosecution, patent prosecution. Once the grant is issued, within 7 days, you will get the certificate from the IP office that this is granted, and the maintenance is for 20 years. So these are all these stages: filing application, provisional or complete. Second, publication of application promptly after 18 months. Request for examination within 48 months from the filing date. Examination issue the first examination report. The third party representation is there that will allow the objections to be compiled within 12 months. Once the FER is received, if any objections are there, that we can give or reply within 12 months. If we reply within 12 months, they will grant the patent. And once we get it within 16 months, within 12 months, if opposition raised, we have to give answers for that opposition. And ultimately, the decision of controller would be there. And on appeal, it goes to the appellate board. And again, either it revoked or amend. Revoke yani nikal denge. It will revoke, removed it if the opposition is very strong. And if it is not there, then it goes to the grant. Okay, so this is what for patent procedure, patent filing procedure. I have already told you for foreign filing, either you can go for a direct filing route, convention application, you can directly go to the Europe and file their application. But the required is initially you have to file this patent in India, being an Indian, right? After 6 months, you can go for filing outside the India. Okay, then through PCT route, you can apply or you can submit it in multiple countries in a one click as it's online process, and it is under the Paris Convention route. Okay, so these are the acknowledgements, and thank you for this